Good evening, officers. This is Amrinder Singh Shergill, Additional District and Sessions Judge, working as faculty member with the Chandigarh Judicial Academy. This online session is being held by the Academy on account of the directions given by the Honorable High Court in Civil Original Contempt Petition number 1663 of 2020, titled as Saroj Kanta versus Jay Parkesh and others. The said decision has come on 29th March 2023 and have been duly circulated to all of us. What the Honorable High Court noticed during the said case is a disturbing fact. The fact that the number of contempt petitions were being filed against serving young judicial officers. Majority are from Punjab, and these young judicial officers are daring to interpret the order passed in the Asian resurfacing case as per their own convenience. They are not interpreting the said order in its letter and spirit. Accordingly, a direction has been given to the Academy to hold an online seminar to sensitize all the judicial officers from the states of Punjab, Haryana, and UT Chandigarh regarding the interpretation of the Asian resurfacing case. Accordingly, we are here. The title of the case is Asian Resurfacing of Road Agency Private Limited versus Central Bureau of Investigation, and the citation is 2018 16 SCC 299. I repeat the title and the citation. It is Asian Resurfacing of Road Agency Private Limited versus Central Bureau of Investigation 2018 16 SCC 299, which has been decided by the Honorable Supreme Court on 28th March 2018. It was a bunch of criminal appeals which were being heard by the Honorable Supreme Court, and the question before the Honorable Supreme Court was whether the order framing charges is an interlocutory order or not. While hearing this matter, the Honorable Supreme Court noted that delay in criminal trials has deleterious effect on the administration of justice, in which the society has a vital interest. The Honorable Supreme Court noted that delay in trials affects the faith in rule of law and efficiency of the legal system. Honorable Supreme Court further noted that the delay affects social welfare and development. Even in civil or tax cases, it has been laid down that power to grant stay has to be exercised with restraint. In para number 35 of the said judgment, the Honorable Supreme Court noted that the situation of proceedings remaining pending for long on account of stay needs to be remedied. Remedy is required not only for corruption cases but for all civil and criminal cases where on account of stay, civil and criminal proceedings are held up. The Honorable Supreme Court further noted, at times proceedings are adjourned sine die on account of stay, and even after stay is vacated, intimation is not received and proceedings are not taken up. In order to remedy the same, the Honorable Supreme Court has told us as to for how long the stay will remain in operation and after which period, unless and until a stay is extended by a speaking order, the stay will be deemed to be vacated and the proceedings are to commence, and which are the matters on which the same will be applicable. I have divided my session in three parts. The first part is devoted to the superior courts which are to grant stay as to on what parameters the stay is to be granted and what is the reciprocating duty on the court granting stay. The second part of the session is dedicated to what has been directed to be observed and carried forward by the trial courts. And third part will be devoted to the direction given by the Honorable High Court in the said case. Coming to the first part regarding the courts which have to grant stay of the proceedings of the lower courts. The Honorable Supreme Court in para number 29 of the Asian resurfacing case has held that mere prima facie case is not enough. Party seeking stay must be put to terms and stay should not be an incentive to delay. The order granting stay must show application of mind. The power to grant stay is coupled with accountability. In para number 30 of the said judgment, the Honorable Supreme Court has held that wherever stay is granted, a speaking order must be passed, showing that the case was of exceptional nature and delay on account of stay will not prejudice the interest of speedy trial in a corruption case. The Honorable Supreme Court further held, once stay is granted, proceedings should not be adjourned and concluded within 2-3 months. So the underlying directive is the stay should not be granted casually. It has to be granted in a befitting case, that too by passing a speaking order reflecting the application of the mind, and once the stay is granted, the effort should be to conclude the matter, to conclude the hearing by the Superior Court granting stay within 2 to 3 months. In para number 35 of the said judgment, the Honorable Supreme Court has further noted that unless an exceptional case is made out and by a speaking order, a stay is to be extended. That means only in an exceptional case that the stay is to be extended, and that too by a speaking order. The speaking order must show that case was of such exceptional nature that continuing the stay was more important than having the trial finalized. Now coming on to the second part of the session as to what the trial courts have to see. The Honorable Supreme Court has ordered that In an attempt to remedy the said situation, the Honorable Supreme Court has directed us that in all pending cases where stay against proceedings of a civil or criminal trial is operating, the underlying wording is all pending cases of a civil or criminal trial. So this direction is only in a trial of civil or criminal nature. The Honorable Supreme Court has directed the same will not come to an end on the expiry of 6 months from today, unless through an exceptional case by a speaking order stay is extended. I repeat the direction that in all pending cases where the stay against proceedings of a civil or criminal trial is operating, the same will come to an end on expiry of 6 months from today, unless in an exceptional case by a speaking order such stay is granted. That means where a civil trial or a criminal trial is pending before a court, and in the said trial the proceedings have been stayed, they will come to an end. The stay will come to an end after the expiry of 6 months period, unless and until the stay is extended in an exceptional case by a speaking order. The Supreme Court has further directed that in cases where stay is granted in future, the same will end on expiry of 6 months from the date of such order, unless similar extension is granted by a speaking order. The speaking order must show that the case was of such exceptional nature that continuing the stay was more important than having the stay finalized. The Honorable Supreme Court has directed that the trial court where order of stay of civil or criminal proceedings is pending may fix a date not beyond 6 months of the order of stay, so that on expiry of period of stay, proceedings can commence unless order of extension of stay is produced. Here also the underlying word is trial court. The court who is trying a civil suit or who is trying a criminal trial. In para number 36, concluding the directions, the Honorable Supreme Court has said in all pending matters before the High Courts or the other courts relating to the PC Act or all other civil or criminal cases where stay of proceedings in a pending trial is operating, stay will automatically lapse after 6 months from today, unless extended by a speaking order on above parameters. That means in whatever case which is a trial pending on the civil side or on the criminal side where the proceedings have been stayed, unless and until they are extended in an exceptional circumstances by a speaking order, the stay will automatically lapse after 6 months, and thereafter the trial court will be duty bound to proceed with the trial of that very case. The Honorable Supreme Court has directed that same course may also be adopted by civil and criminal appellate as well as revisional courts under the jurisdiction of the Honorable High Courts. The trial courts may, on expiry of the above period, resume the proceedings without waiting for any other intimation unless express order as extending stay is produced. In para number 37 of the said judgment, the Honorable Supreme Court has said the High Courts may also issue instructions to this effect and monitor the same so that civil or criminal proceedings do not remain pending for unduly period at the stage of trial. The Honorable Supreme Court in the same case had an opinion on 25th of April 2022. The citation is 2022 SCC Online SC 1014. The Honorable Supreme Court has held in the said order that we must notice that the direction issued in Asian Resurfacing of Road Agency Private Limited versus Central Bureau of Investigation 2018-16 SCC 299 case arose out of the factual and legal matrix present therein. The case revolved around the questions arising out of the pendency of civil and criminal cases, that is, of trial being halted, and the tendency towards procrastination on the strength of the orders of stay granted. Here again the word used is trial. The result was that cases were not being taken to their logical conclusion with the speed with which they should have been done. Again, the Honorable Supreme Court in the same case had an occasion to pass an order on 15th October 2022 in Criminal Appeals 1375-1376 of 2013, while disposing of a miscellaneous application number 1577 of 2020. The Honorable Supreme Court has held that we expect that magistrates all over the country will follow our order in letter and spirit. The order passed in March 2018. The Honorable Supreme Court has further held whatever stay has been granted by any court, including the High Court, automatically expires within a period of 6 months, and unless extension is granted for good reason, as our judgment, within the next 6 months, the trial court is on the expiry of first period of 6 months to set a date for the trial and go ahead with the same. Now culminating the session, what we have noticed is that the stay is only to be granted in an exceptional cases. It has to be granted by a speaking order. Where the stay has been granted, the endeavor should be to dispose of that matter as early as possible and preferably within 2 to 3 months. And in case there are exceptional circumstances that the matter could not be disposed of accordingly, the stay has to be extended by a written speaking order reflecting the application of the mind. And the trial courts have to obey the extension of the stay granted by the Superior Court. However, if the parties do not produce or the trial court do not receive any order extending the said stay by a speaking order, the trial court will be at liberty to resume the proceedings in the trial. However, these directions are only applicable to the trial courts holding and conducting the trials on civil and criminal sides. They are not applicable on the miscellaneous proceedings, including the execution proceedings. With the result, the Honorable High Court in Saroj Kanta versus Jayaprakash has directed the Academy to hold an online session to sensitize the officers regarding the said aspect. The Honorable High Court, while going through the said directions, has also noticed the 2 judgments of the Honorable Andhra Pradesh High Court, Grandhi, Yugandhar and another versus Messrs. Jyoti Financiers, represented by its managing partner Samaya Mantula, Umanaveshwara Rao, 2012-6, Andhra Pradesh LD 195, and the other cases Bolisetti, Prem Sai versus Ralapalli, Venkata, Lakshmana Swamy, 2022-3, Law Summary 27, and another judgment of the Honorable Bombay High Court in case titled as Rao Sahib Yesba Sartape versus Balbir Shankar Sartape and others. Citation is 2021, Volume 5, AIR, Bombay, are 496. In all the said cases, the interpretation made by the High Court says that the directions in the Asian resurfacing case only apply to the stay of trial and not to the executing proceedings. So therefore, if an execution proceeding is pending before any court, please note that the directions given in Asian resurfacing case are not applicable on execution cases. It is only applicable on trial cases, the trial on the civil side as well as trial on the criminal side. The directions to all of us by the Honorable High Court in the said case decided on 29th March 2023 is that all the civil judges, judicial magistrates in the states of Punjab, Haryana and UT Chandigarh, before interpreting the direction in Asian resurfacing case, will seek the opinion of their respective district and sessions judges, being the administrative judges of the districts, and the district and session judges as and when receive such matters with regard to the interpretation of the order passed by the High Court shall give his or her opinion within a period of 3 weeks from receiving thereof. So as and when you have any doubt, please seek the opinion of your respective district and session judge, and after obtaining the opinion so given by the learned district and session judge, please proceed with the matter. With this, I have come to the end of the session. Hope it will be of some use. Otherwise, the said judgment of the Honorable High Court is already circulated to all of you. If still you have any query, please feel free to ask the Academy. The Academy will be duty bound to help you out. With this, I come to the end of the session. Thank you so much. Have good time. Thank you so much.